Hello, my name is Dr. Vishwas Devaya. I'm an associate professor at Jindal Global Law School, Sonipat. Today we are focusing on universal origins of intellectual property rights. We begin with the origins of copyright, then focus on origins of trademark, and lastly we'll end with origins of patent law as such. So let's begin with origins of copyright. Origins of copyright can be traced back to early days, but when you look at the early days, a lot of the writing used to happen on leaves and parchments, which basically meant it kind of slowed down replication of works that were actually written down on leaves and parchments. Romans actually practiced a system of dictation that allowed many copies of the same book. In this way, they could actually kind of replicate many books simultaneously by using scribes. But even with this kind of a system, you had a very slow way of actually replicating books, which basically meant the flow of information was pretty much restricted. Subsequently, you had a system of wooden print blocks that were invented in China, but was largely unused in Europe until the 15th century, when there were certain breakthrough in the technology. We had two specific developments in the 15th century. One is the use of paper, which was an important step in towards developing of publishing works. Secondly was the invention of the movable printing press by Gutenberg in the 15th century, which allowed printers to actually make several copies of a literature. This resulted in thousands of books coming into circulation, and all of a sudden you had a spurt in the number of books that were available in the marketplace. Many works that were largely confined to a particular territory or region because you didn't have a printing press could now be easily copied in a short span of time. Unfortunately, when the printing press came into being, there was definitely, no doubt, a growth or a spurt in the number of books that were published. Subsequently, it basically meant that there was a lot of flow of information, and it was at times difficult for the royalty to control as to what is being printed. Even the church was kind of concerned as to what is actually being published. As a result of the spurt in the growth of publishing, you had the censorship regime actually coming into play. With the advent of the printing press, there was a challenge to the church and the monarch, as there were many books and literature that were critical to the practices of the church and the monarch. One way of controlling such works, largely censorship. Initially, church prevented a number of heretical works from being published. Subsequently, the monarch used different instruments to actually control and regulate the flow of information. Printers were basically licensed to print certain books for a fixed number of years. These were granted in the form of privileges. Earliest privilege granted in the city of Venice, right? These privileges would usually be granted to printers to exclusively publish a particular book for a period not exceeding 14 years. In England, Queen Elizabeth would grant privileges in the form of monopolies to printers, right? So with censorship, there was a lot of resentment in terms of the kind of people who would come up with literary work, but because it was either critical of the royalty or critical of the church, it wouldn't actually get distributed because largely the church and the royalty controlled publication of material largely by licensing printers. Then in the 16th century, there was a brainwave wherein Edward VI granted what is called as the Charter of Stationers' Company. The charter basically allowed mostly the London-based printers the power to govern and control the printing of books, right? Instead of actually kind of the royalty or the church getting involved directly in the process of censoring books, you had the stationers company actually controlling what actually gets published and what actually gets distributed. It allowed them to search for illegal printers and illegal printers and books. Largely, powers were granted to the stationers company to go to places, do searches, and if they found an illegal printer or a book that was not necessarily allowed to be printed, they could actually confiscate it. They had the seizing power. They could actually burn the books that were not registered with the stationers company. Right? Further, later on, the king effectively exercised the censorship through the company. So, in effect, you had a chain system wherein the king would actually come into play, and he would largely act through the stationers company. The stationers company also benefited as it allowed them to prevent entry of new printers as well as control the flow of information. Printers who were part of the stationers company benefited largely because they could exclude new printers from entering because they wouldn't give them license. Secondly, they monopolized what was to be printed. So, they basically control the flow of information through the stationers company. Right? The stationers company, right, created their copyright and kept control of it for themselves. Right? The first English copyright, the stationers copyright, was largely a private law copyright. It was defined only in the ordinance of the stationers company. Registration of the book's title was absolutely mandatory. From 1662 onwards, they had passed a licensing act which required anyone who wanted to publish book to get a license before it gets printed and distributed. This kind of ensured that there was a perpetual monopoly. There were policies to avoid competition. But subsequently, by the end of 17th century, that is in 1694, the powers exercised by the stationers company were basically not renewed by the parliament. This largely kind of ensured that the control or monopoly over the printing press came to an end. In 1709, they formulated what is called as the Statute of Anne, which was passed by the English Parliament that recognized the rights of the author. This was the earliest legislation on copyright, basically. Right? What was the form of Statute of Anne? If you look at the Statute of Anne, basically came into existence or force in 1710. It was largely aimed at encouraging learning. It started to vest rights in the author to print and copy their own works. It basically protected the publishers by protecting whatever they published for a period of 14 years. The author's exclusive right was largely for a period of 14 years, but it could be extended to a second term of 14 years if the author was alive by the end of the first term of 14 years. Subsequently, any previous work, that is, any work that was actually written prior to 1710, that is before the Statute of Anne came into force, was also kind of protected for a period of 21 years. So, Statute of Anne was largely aimed at striking a fine balance between the author, publisher and the public. Right? It largely was based on the fact that if you encourage the authors, give them protection for a certain period of time, they'd come up with wonderful literary works. It sought to protect the interest of all three stakeholders, the printers, the publishers, and the common public. Yeah? But with the Statute of Anne restricting the term of protection to a period of 14 years, there was also a battle of what is called as the booksellers. The battle of booksellers is a fairly important development that happened at a very early stage of Statute of Anne. Largely, the booksellers who were based in London were completely aggrieved about the duration of the protection. They felt that the moment a book fell out of protection, there would be competition for them. Largely, they anticipated that the Scottish printers would begin printing these books, and this would hurt the sales of the London printers, who had so far maintained a monopoly for a number of decades. Booksellers argued that common law recognized a perpetual copyright in the author, and there was no time limit at all. And the Statute of Anne, by actually prescribing a time period for the protection of authors' work, was completely against the common law principle. They also argued that an author could assign the copyright in the book to the bookseller through a contract, which was not specifically mentioned in the Statute of Anne. Multiple cases were filed in the courts, some of which are basically Miller versus Taylor, Midwinter versus Hamilton. But the most important of all the cases is something that we will touch upon in a couple of minutes. The battle of booksellers continued. The London booksellers argued specifically for perpetual copyright on the basis that authors will no longer have incentive to create new work if they do not enjoy protection in their work beyond their lifetime. Any limitation in bequeathing the rights to their family or estate would be a major limitation that would prevent authors from coming with new work. The Scottish booksellers, though, argue that perpetual copyright would actually keep the knowledge in the hands of a few, and this would impede the flow of information. They argue that this is nothing short of actually going back to the Dark Ages. The most important case that was fought during the Battle of Booksellers is known as Donaldson versus Beckett. The booksellers were dissatisfied that the Statute of Anne only allowed for a monopoly period of 21 years for works that were created prior to Statute of Anne coming into force. If perpetual copyright ownership was allowed, then works written by Shakespeare and others would actually allow the printers to maintain their monopoly. They argued specifically for perpetual monopoly, and stating that common law actually recognized such a right. But the House of Lords actually dismissed the case and confirmed that there is no perpetual monopoly with respect to works that are written by authors. They said works beyond 21 years would actually be made available in the public domain for everyone without any restriction at all. This decision allowed a number of famous works like that of Shakespeare to be made available in the public domain. Right? So thus started the modern copyright law. Then you had in 1886 the Berne Convention, which allowed for protection of literary and artistic works. Subsequently, you had the TRIPS negotiations, and you had trade-related aspects of intellectual property rights. You also had the WIPO Copyright Treaty in 1996. With that, we end the discussion on origins of copyright law. Now,